Seriously. You don't feel dizzy right now, do you?
Yeah.
You're feeling dizzy?
Yeah.
Okay.
1 second, we're going to get the stretcher in here, okay?
On April 19th, 2020, Harvard Police Department in Illinois responded to an accident scene at 703 South Eastman Street. The driver's blood alcohol content 0.42%, over 5 times the legal limit.
Did you black out, or I mean, what happened?
Yeah, I did.
You did black out.
Yeah, I did.
Okay. All right. Well, they're gonna talk to you and just get some stats from you, okay? They want to take you out because this isn't normal, and you seem very lethargic and slow right now. So I have to figure out what's going on with you. You're telling me that you weren't drinking, you didn't take it. You're not on any medication?
Yeah, is it one of your cars he hit, or?
We think he might have just bumped this one. I don't see any damage. I'm
We
not
heard
really,
like
yeah.
a bump sound when we were in our living room, so we looked out the window and he was right, like the truck looked like it was lined up with the...
Okay, but no damage to it?
No.
Yeah.
Well, he's my friend's dad. He's been actually staying over here. My main concern is I know he's had like cardiac issues, so I don't know if he blacked out or if there's something else going on. So we just want to make sure he's okay.
Medical issues? Yeah.
Alright, so you were just inside watching?
Yeah, we were playing video games at the time, and then we heard the sound in our driveway, and I looked out, and there he was. So, we weren't sure if he was turning around, but...
I'm getting a valid registration to a black 2007 Dodge pickup to a Kevin out of Poplar Grove. The 27 files attached, he's valid.
10-4, print that, please, folks.
10-4.
Seriously. You don't feel dizzy right now, do you?
Yeah.
You're feeling dizzy?
Yeah.
Okay.
1 second, we're going to get the stretcher in here, okay?
Under Illinois Statute 625 ILCS 5/11-501, driving under the influence is defined as operating a motor vehicle with a blood alcohol concentration of 0.08% or higher, or while impaired to a degree that renders the person incapable of driving safely. The elements prosecutors must prove include: first, the person was driving or in actual physical control of a vehicle; second, they were under the influence of alcohol; and third, this occurred on a public way. All 3 elements are present in this case. When the suspect confirmed feeling dizzy, officers immediately called for a stretcher. This was the correct decision. Illinois courts have consistently held that officers have a legal duty to provide reasonable medical care when a person in their custody requires treatment. Difficulty walking and loss of balance are classic indicators of severe alcohol intoxication. At 0.42%, most individuals would experience stupor, confusion, and severely reduced motor control. This level is potentially life-threatening. During the vehicle inventory, officers discovered 2 empty Skull vodka bottles. Under Illinois law 625 ILCS 5/11-502, having open containers of alcohol in a vehicle is illegal. More significantly, this provides strong corroborative evidence of alcohol consumption immediately before or during driving. Illinois law does not require that a person be driving at the moment police arrive. Being in actual physical control of a vehicle while intoxicated is sufficient for a DUI charge. The fact that the suspect had just collided with a parked vehicle provides clear evidence he had been driving moments before.
I got him. You want to grab
They got it coming. Alright, hold up. Alright, we got the stretcher right here, okay? So we'll have you sit down on it, okay? Is that family over there? Alright, you want to have a seat right there, man? Have a seat right here, okay?
Yeah.
Couple steps over,
No.
okay?
They said he lives next door, or down. He's living with some friend on the road here, and they think maybe he thought he was at the wrong. He was at their house, and
His daughters. They were living in Canada. His daughters kicked him out.
You just feel like you're going to fall over, so very good there, yes. I'm going to help you with your legs, okay? This way.
what do you? I mean, they said there's no damage. There's no 1050 needed. What do you want us to do?
No.
No, he doesn't live here. He just.
doesn't know them at all or anything.
I was thinking that.
He stays. I live next door. He stays with me.
Okay.
But I think I want my garage door open in case you're taking this truck away. I don't want to lose my.
I said that when I walked up. Oh yeah, I'll get it.
You want to hand it out to me? Because I don't know what to do with that truck.
Yeah. How long has he been living with you for?
Last several months.
Last several months. Okay.
Yeah, when I walked up, I said that. I said, look at his eyes. He's hammered. You just don't listen to me anymore. You
I'll listen to you.
just had a whole conversation with you. No?
That's what I do.
Well,
no drinking in those drugs that I know of, but I don't. I mean.
No, here.
Nick.
Here. Hey.
Nick.
Thank you.
Hey, pretty good chances. Getting cold out here.
What is in that bottle? Is it booze or something?
2 empty bottles of vodka.
That's empty.
At the hospital, the officer attempted to read the Illinois Warning to Motorists as required by Implied Consent Law 625 ILCS 5/11-501.1. However, the suspect was in a semi-conscious state and unable to provide meaningful responses. A complex legal question arises: how to comply with implied consent requirements when the suspect is too impaired to participate in the process. Illinois courts generally hold that officers must make reasonable attempts to advise, but the suspect's incapacitation doesn't automatically invalidate the case. The following day, the officer returned to the hospital when the suspect was alert to complete the advisement process. This demonstrates good procedural compliance and ensures the suspect understands the legal consequences. The officer explained the charges: driving under the influence, accident-related violations, and open bottles in the vehicle. This was the first time the suspect was fully aware of the legal situation he was facing. The suspect asked whether he was pulled over. The officer patiently explained that police responded to an accident call, and when they arrived, the suspect was intoxicated in the vehicle, which constitutes DUI under Illinois law. Illinois law authorizes law enforcement to have vehicles towed when the driver is arrested or unable to operate safely. This serves both public safety and property protection purposes. The officer suggested the suspect consider obtaining an attorney or requesting a public defender. This is sound advice. DUI cases involve complex legal and procedural issues, and representation can make a significant difference in outcomes. Although the suspect technically refused to sign the Illinois warning form and consent to blood testing, hospital staff informed police that the suspect's blood alcohol level was 0.42%, over 5 times the legal limit of 0.08%. A complex legal question arises when hospital staff draw blood for medical purposes, and that blood reveals criminal-level intoxication. Can police use that information? This involves complex intersections of medical privacy laws and state DUI statutes. Kevin was charged with 4 different offenses driving under the influence of alcohol, accident-related violations, and open bottles in the vehicle. The first DUI charge was dismissed through a prosecutorial decision called nolle prosequi. However, Kevin negotiated a plea deal with the court and was found guilty of the second DUI charge. He was sentenced to 18 months conditional discharge, 240 hours of public service, mandatory DUI school, and fines. Notably, he did not receive jail time for this offense. Illinois law recognizes different penalty structures for first, second, and subsequent DUI convictions, with jail time typically not imposed for first offenses without aggravating factors. Public records also show that on October 30th, 2020, Kevin was convicted of aggravated criminal sexual abuse of a victim less than 13 years old. This is a serious felony offense that resulted in jail time and probation. The alcohol treatment requirement in both sentences suggests the court recognized alcohol as a contributing factor to his criminal behavior. After 103 days of failing to claim the vehicle, ownership was transferred to the towing company.
Can you tell me what room a fine gentleman's in?
You know, who is 108?
Kevin?
Yeah, 108.
108?
Yeah.
Thank you, ma'am. Kevin, how you doing? I just got some paperwork to give you. I left you a bunch of paperwork yesterday, too. What's that?
I messed up, didn't I?
It's alright, it happens. Oh, it shouldn't happen, but nobody's perfect either.
You know, I mean, 15 years old. First time getting in trouble, you know. I had a bad day.
Yeah.
Everything's building up on me.
I get it. I get it, man.
It sucks.
It's crazy right now, you know?
Yeah.
You just go out and just party too much or what?
No, I brought the bottles home, sat in the garage,
Okay.
and drank.
Oh, and then got back in the car afterwards?
Yeah, I sat in the garage drinking it.
Got it.
And then I guess I pulled around to the neighbor's house there and bumped her car, and I don't know what happened after that.
Okay.
I mean, it wasn't like I was driving down the main street or anything. It happened about where else, but
Okay.
all I know is I got out and drove to their driveway.
Alright. I just got some stuff. I'll leave it on this table for you. These 3 things here are all together. You don't have to get up.
Yeah, well,
Nothing's that important. These 3 things here are all for the accident. Just statistical data only. Just if you want to fill it out and send it in, your version of it.
okay.
Um,
She said she wasn't going to press charges or anything like that.
yeah, no. This is just because there was an accident.
Okay.
So she's got one too. I went and dropped one off over there. That's how I knew you were still here, because I thought you were home already.
All right. Yeah, I don't know why they're keeping me in here, you know. And what else do I got?
This one here is a citation for no insurance.
I have insurance.
Okay. Well, we didn't see it when we went through the car.
It's in that arm rest when you lift it up. The paperwork's are all in there.
Okay. Yeah, we didn't see it last night through the
okay.
car.
Yeah,
so all you got to do is there's a court date on here.
All right.
June 3rd at 1:30 at McHenry County.
Okay.
Just go and show them the insurance card, and they'll just take care of it.
Oh, okay.
Yes, that's no big deal.
All right.
This one here, just have you sign. It's for, you obviously didn't post any bond yesterday. You came here, so we didn't take it down to the station, process you.
Right.
This one here just says that you're out on an NTA, notice to appear, and that you know you have court on the 3rd of June at 1:30.
Okay. So, am I going to jail now after I get out of here?
No.
Oh.
No, this is a notice to appear.
Okay.
Says you don't have to come down to the police department. You're not going to jail. You just have.
All right.
Oh, that bottom line there by the X. That's right. Yeah, it says you're not going to jail. It just says that you have to make sure you go to court, though.
Yeah, I got court in Boone County too.
And one right there. What do you got court in Boone County for?
Well, long story, a false story. Girl said I molested her.
Yeah, that'll get you to court.
Yeah, lies. She pulled that on 2 different other people.
Okay.
She can't live with her mom or anything like that because her boyfriends supposedly did it to her too, and didn't touch that girl.
In regards to this case, Kevin was found guilty of aggravated criminal sexual abuse to a victim less than 13 years old on October 30th, 2020. He was ordered to pay a total of $4,014. This amount has been paid in full. He was sentenced to 128 days in jail with 64 days credit time served, 4 years on probation, and ordered to participate in alcohol treatment.
But because of the circumstances, that's why the admin was placed. Nope, that's your copy. I'm going to see if I can get a cap. I'm sorry, go ahead.
Go ahead, I'm sorry.
I'm just going to see if I can get them to make a copy of this real quick so I can leave you one.
Alright.
Did you have a question?
Yeah, am I being charged for a DUI?
Yeah, so yesterday, the paperwork I left you yesterday was for driving under the influence, the accident, the ticket for the accident, and then for the open bottles in the vehicle.
So, did you guys actually pull me over?
Did we pull you over?
Yeah, I mean,
no, we responded to the accident.
Okay, because I was in the vehicle at the time.
Correct. So they called because you hit their car.
Okay.
And then when we got there, you were intoxicated. You were in control of the vehicle, so it becomes a DUI.
Oh. Okay. So what do I do about all that?
You've got court on the 3rd of June for all that.
For all of it?
Mm-hmm. You can. I can't give you legal advice. If you want to get an attorney, they can. All I can tell you is that you've got.
I can't afford one. I got a public defender in Boone County.
Yeah. So all I can tell you is that you have court in the 3rd at 1:30
Okay.
for all four
For all
citations.
four.
Yep. Tried to make it easy for you, so you only had to go once.
Yeah.
And then if you want to contest this, the 4th of June, the next day.
No. They can have it's up for repo anyways. Got a title loan on it. You know, the kid wanted me to get, because they were getting behind the bills, and they were going to help me pay it back.
Didn't help you pay it
Didn't
back.
help me pay it
Yeah.
back. So, title loan place wants the truck.
Got it. Yeah, if you want to call the cranes when you get out here and let them know what's going on.
All right.
All right, let's see if
And
I
then I
can.
owe you $500
You don't know, that would be for the city.
for the city.
Yeah. So let me see if I can get you a copy of this. I'll be right back.
All right.
Kevin, here's a copy for
All
you.
right, buddy.
That's just a copy of that document that you signed.
Sorry about all this, you guys. You know,
Like I said, man, it happens. It's not a reoccurring event, so if it was, then
yeah,
you know.
it's the first time.
And they know that. I mean, if you look at the sentencing docs that I gave you, first-time offenses
Yeah.
are not obviously second, third, and so on are worse.
Right.
So,
But I do need to drive again.
well, that would be things that you can, if you wanted to get a public defender or an attorney, you could talk to at that court date. So,
All right, buddy.
all right. Any other questions?
No, sir.
All right.
Thank you.
Harvard Police Department officers grade B+. Officers demonstrated professional handling with appropriate prioritization of medical welfare over immediate criminal processing. Positive aspects: medical prioritization when the suspect reported dizziness, professional demeanor throughout, thorough investigation, proper coordination with EMS personnel, and good follow-through by returning to the hospital the next day. Areas for improvement. The implied consent advisement to a semi-conscious suspect created legal complications. While the officer made good faith efforts, clearer documentation of the suspect's level of consciousness could strengthen future cases. Legally, officers had clear, probable cause to investigate and arrest for DUI response to accident call. Suspect found in control of vehicle at accident scene. Obvious signs of intoxication, and discovery of empty alcohol containers. Tactically, officers showed good scene management and officer safety awareness. They maintained appropriate positioning, coordinated effectively with multiple parties, and avoided escalating an already volatile situation with an extremely intoxicated subject. Kevin grade F. Kevin's conduct represents an almost complete failure to act responsibly or legally. Driving with a blood alcohol content of 0.42%, over 5 times the legal limit and approaching potentially lethal levels, demonstrates extraordinarily reckless decision-making that endangered not only himself, but every other person on the road. The fact that he actually struck another vehicle shows his impairment, directly caused property damage, and could easily have caused serious injury or death. 2 empty vodka bottles suggest he was likely drinking while driving. Kevin violated multiple Illinois statutes, 625 ILCS 5/11-501 for DUI with BAC over 0.08%, 625 ILCS 5/11-502 for transporting alcohol in a vehicle, and duties upon striking an unattended vehicle. The only significant mitigating factor is that this appears to have been Kevin's first DUI offense. However, the severity of the intoxication level and the existence of a separate serious criminal conviction limit the weight this factor should carry. Harvard Police Department institutional grade A- as an institution. Harvard Police Department demonstrated strong policies, training, and accountability in handling this incident. The response shows a department with clear procedures, appropriate priorities, and professional standards. Officers acted consistently with department expectations and legal requirements. The case was processed thoroughly from initial response through prosecution support. Appropriate policy on medical emergencies shows the department correctly values life and health over immediate criminal processing. Thorough investigation standards and professional training are clearly evident. Key lessons from this case. First, always prioritize medical safety in cases of severe intoxication. No case is more important than human life. Second, clear documentation is critical. Record the suspect's condition, efforts to comply with procedures, and any challenges encountered during investigation to protect the integrity of the case. Third, balance legal requirements with practical realities. When suspects cannot participate in legal procedures due to their own impairment, make good faith efforts, document those efforts, and follow up when possible. Finally, professionalism matters. Treating suspects with basic human dignity, even while holding them accountable, reflects well on department training and culture, and helps maintain the legitimacy of the case in court. This case underscores why DUI laws exist and why they must be enforced. Impaired driving kills. Extreme impairment like this is an act of recklessness that could easily have resulted in tragedy. A BAC of 0.42% is not the result of having a few drinks and making a poor decision. This level of intoxication indicates consumption of a massive quantity of alcohol, with profound disregard for personal safety and the safety of others. The financial consequences of DUI extend far beyond court fines, towing costs, impound fees, increased insurance rates, and attorney fees can total thousands of dollars, creating a long-term burden for those convicted. Kevin's failure to receive jail time for the first DUI offense reflects Illinois' approach of rehabilitation over punishment for first-time offenders. But subsequent offenses would result in far more severe consequences. The combination of the DUI sentence and the sexual abuse conviction shows alcohol was a contributing factor to Kevin's criminal behavior. Mandatory alcohol treatment in both sentences is critical to addressing the root cause. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching. And don't forget to subscribe to the channel for more police interaction and courtroom content.